Start it when she. Oh, she got it.
All right. Good morning. This is Breakout Room 5. The session is How Private is Your Private Life? We're going to be discussing off-duty misconduct, particularly in a rapidly changing world and due to COVID and technology. I'm Stephen Schwartz. I'm a arbitrator on AAA's labor panel. We're joined by two very experienced advocates. Presenting the management perspective will be Marcero, who we hope to have visual. We had visual at 15 minutes ago and lost it with her. And representing the union perspective will be Karen Schneider.
Good morning.
We'd like people to ask questions in the chat, and we will try to incorporate answers over the next hour to your questions from the chat. So Leah, if we could go to page 3, guiding principles. So essentially, Martha and Karen are going to elaborate on this in a few minutes, but there is a tension, which of course sometimes happens between management and unions, but there's a tension as to what employees are free to do or not free to do off duty. So typically the management perspective is, as a public employer, as a private company, we have the right to discipline for misconduct to maintain our organizational and operational interests. And the union response typically is, gosh darn it, and that's usually how union folks talk, gosh darn it, management, people can do what they want to do when they're off duty. You can't interfere with their private lives. And you only get to say something that really affects their job or the employer's operation. And so as arbitrators, we have to reconcile these competing interests of the union trying to protect the right of employees to do what they want off duty, and management's concerns about how it affects what employees are doing off duty that affects their operation. And so arbitrators have to juggle that, particularly when we're involved in discipline for off-duty misconduct. Leah, if you go to the next slide, please. So arbitrators generally use 5 criteria. We're going to elaborate that in the next few minutes. In the pivotal question, and the word was probably used by some lawyer, and lawyers can never use normal language. So is there a nexus? Is there a connection between the off-duty misconduct and work, in the employer's operation? If as a general principle, if the employer cannot establish any connection or a strong connection between the off-duty misconduct and what the employer is doing, then the employer arbitrators typically say there's no basis to discipline or try and restrict that behavior. If there is such a connection, then there may be a basis for discipline and restrictions and policies that restrict it. The criteria typically used by most arbitrators is, 1, can the employer show damage to their reputation or to their business? If in a private sector, if the reputation affects their ability to maintain their customer relations and market, or in the public sector, the public's faith in that operation, if they can show an actual loss in the private sector, or somehow undercuts in the public sector the view of the integrity of the governmental unit. If the off-duty misconduct, secondly, affects the ability of the employee to be available to be at work because they're either in jail or they're somehow can't report to work. Third, if the employee is fired by the employer and the arbitrator is wrestling with, do I reinstate the person? What's the impact on the rest of the bargaining unit, the other employees, union and non-union, the employee and supervisors, or what's the relationship between the employee and the customers that they interact with? Is the employee, because of their off-duty misconduct, unsuitable for a continuing employment? It's a nebulous standard. We're going to get into that in a minute. And fifth, this is a little more objective. If the person lost an occupational license or certification that they would be required to have in order to perform their function. Let's go to slide 5, Leah. Next slide, please. Thank you. Martha, give us management's perspective on this, and then Karen, follow up with the union's perspective.
Okay, as an initial kind of introduction, my area of practice is involving K-12, primarily K-12 public schools. And so my perspective is entirely based upon the public sector, which of course is governed by a whole different set of rules and criteria. And Karen's similarly situated. And so as a consequence of whenever you're dealing with this kind of off-duty misconduct in the public sector, there's a lot more variables in relationship to what governs the employment and things of that nature. Obviously, whenever you're dealing with a collective bargaining agreement or individual contracts, or board policies, practices, things of that nature, your first criteria that you're always looking at is what is the standard for disciplinary action involving that employee or that employee group. And as you all know, it can be anywhere from an at-will employment status to a just cause standard, which obviously creates a significantly higher obligation with regard to what your proofs are and how you're going to insert your proofs. Then you've always got to, when you're again dealing with off-duty misconduct, look at any contract language, policies or procedures that are in place in relationship to what you can govern in from the employer's perspective. In general, collective bargaining agreements in the public sector, at least in the K-12 districts, you always have language that says that their personal lives are their personal lives unless it adversely impacts the operation or the status of the employer in some manner. And then you would have to identify how, again, going back to the nexus piece of the puzzle. You also would have to make sure that you're enforcing whatever policies or procedures in a manner that's consistent with anti-discrimination laws. You've got to make sure that you're not getting or treading into arenas with whistleblower protection acts, and that would apply both in the private or the public sector for the whistleblower statutes. And then finally, primarily, again, in the public sector, you're going to have to consider the constitutional First Amendment rights of freedom of speech involving that employee and what is the magnitude and whether it falls within the exempt areas. Finally, you also have to consider what the statutory language is of your state in relationship to union activities, things of that nature. If it's in the public sector, whether it's protected concerted activity under the NLRA, or in Michigan, if it's protected activity under the Michigan Employment Relations Commission. So you've got to take each piece of that puzzle and examine whether the off-duty misconduct can surpass any of those statutory guidelines or constitutional implications before you get into what discipline you're going to even consider based upon the overall facts, the context of the speech, the nature of the speech, and things of that nature.
Thank you. Karen, union perspective.
Thank you very much. By way of my background, I have been a practicing advocate for many years. And during that period of time, I have represented both employers and labor organizations. I'm also an arbitrator for the American Arbitration Association, as well as the Michigan Employment Relations Commission. My perspective this morning, however, is going to be the union's perspective. And we start off with the proposition that discipline for off-duty misconduct is impermissible unless you can establish some harm to the employer. The harm has to be something more than just speculation. It should be actual harm, something that's measurable, something that's demonstrative, and unions need to insist that it be proven. What I like to do with these cases is start from the proposition, again, that discipline is impermissible for conduct away from the workplace, off duty, and analyze the case first and foremost in the context of the classic just cause test. Let's not forget that. These principles that Steve articulated a few minutes ago, this, in my opinion, is frosting on the cake from the union's perspective. It is additional arguments and permutations to present in connection with your defense over and above that classic, was there a rule? Is the rule reasonable? Is it related to the business, et cetera, et cetera. But you still have to do that initial just cause analysis. With regard to these criteria that were articulated and that many arbitrators look at in saying, well, can we take that step beyond and actually justify the discipline for conduct that was clearly off duty and away from the workplace? Then with regard to damage to the employer's business, can the employer show legitimately that there's actual harm, not speculative harm, but actual harm proven in a measurable way? And you do that through, has there been a loss of your customer base, a loss of sales? Have students been pulled from classrooms? Has there been a lot of notoriety? Has there been a public outcry, et cetera? Is the person unavailable for work? Well, typically that means they are incarcerated for some period of time. Is that period of time a lengthy period of time? Is it less than what a person who has been granted some type of leave has enjoyed having time off? If the person is gone from work, what is the impact on the employer's operation? It's one thing to say that, well, the individual is unavailable. It's quite another thing to demonstrate that that unavailability has an impact on the business itself. Does the employee still have a license or certification necessary to do the job? Once again, have there been other instances where individuals have lost certificates or licenses for a period of time and not lost their employment or been disciplined in a harsh manner? Typically, a loss of a license or a certificate, it can be a kiss of death because you're simply not qualified anymore to do the job. But don't just conclude that if someone's unavailable for a short period of time, that is that should breach the employment relationship. Unsuitability. Employers argue unsuitability, and when we hear an argument that's really focused on unsuitability, I think the employer's in trouble. Because what does that really mean? And who measures that? And how is that measured? Is that measured because a couple of people with whom the individual might work have expressed a reservation or displeasure? Does that mean that there's a silent majority that are willing to work with the individual who haven't said anything about it? So do we listen to 2 people over the 317 others who are willing to work with the individual? What is the reasonable person standard in that case? It's a very difficult argument for the employer to make. And I think fundamentally also, what I do first and foremost is I read the contract, the collective bargaining agreement, and I start with the index and I go all the way to the signature line. Don't ever forget to do that, because you will find in the language of that collective bargaining agreement something you can use. Maybe there are some rules of conduct that deal and say specifically, while you are on duty, you shall not blah, blah, blah. Well, that rule then applies to on-duty conduct. And in this day and age, with so many of us still working remotely and individuals having much more freedom, I think you can anticipate from a labor standpoint that you are going to hear more cases being defended from the standpoint that the person was off duty when the conduct occurred, because we are more fluid in when we provide our service, how we provide it, and what our actual hours of work are. So once again, I think that provides the labor potentially with another arsenal to defend in a misconduct case.
Okay, Leo, if you go to the next slide. So whether you are a practitioner in labor relations or you're an academic, or if you're a student and you're going to go into either academia related to labor relations or be a practitioner, the one book you should have in your library is L. Curry, How Arbitration Works. When I acted as an advocate, probably every case before I went to hearing, I pulled it out and read a chapter or two on the subject. As an arbitrator, I almost always look at the principles just to make sure I'm not missing something. So while there are other great books, this is the key. It's pretty well established, and you can have different arbitrators will come up with different results with the same fact pattern, but it's pretty well established that arbitrators will look at certain issues, and we've touched on them, so I'll go over them quickly. Can the employer show harm to reputation or product? The timing of the hearing may matter. If you do a hearing quickly, maybe it's just speculative. If the hearing is a year later and they can show they lost a customer, or a school board meeting was filled with 500 angry parents, that's easier to show. Does somehow the misconduct render the employee unable to perform their duties? If they lost their CDL license because they were driving drunk off duty, and they have to have a CDL to do it, versus can someone else drive? They work in teams and somebody else can drive the vehicle. Do other employees refuse to work with them in a team setting? Does one employee on social media put the breakup of their marriage blaming the second employee, and now a whole group is against the first one? Or if an employee on social media does a racial rant, do other employees who are offended refuse to work with them? Does it somehow undermine the employee's ability to direct the workforce? And again, the more concrete that can be shown, examples or direct effect, that's more persuasive to an arbitrator. The other issue, does the arbitrator, you should always be looking at this issue, preparing for a hearing, what's the arbitrator's jurisdiction? Some contracts say the arbitrator has the right to look at an FMLA issue, look at a constitutional issue. Other contracts specifically say no. If it's discrimination charge, let that go to the courts. We're only dealing with a contract violation. Some arbitrators will rule, well, if you have an FMLA clause written in and it says you'll comply, then that gives the arbitrator jurisdiction. That's not always clear, but that's clearly an issue. We have one question with refusal or reluctance of other employees to work with them. What if some people have moral, in quotes, issues with that, but it's not illegal and the employees expressing themselves like participating in a drag show? This clearly is just a pure hypothetical. Somebody's writing a paper on it. It's never happened. Let's, Martha and Karen, why don't you respond to that? Let's go to the next slide, but try and work in response to that question in your answers. Next slide, unavailability to work.
Well, going back to the question a bit, part of the analysis also needs to be considered is what is the employee's position? Because you've always got to look at different positions in different roles, particularly, and again, I'm coming from the public sector, where if, for example, you do have an employee in a school district who engages in misconduct, when those things end up getting reported in newspapers or get spread around on Facebook, it's always a school district employee gets arrested for fill in the blank, or a school district employee does the following. And so then it obviously gets in widespread attention for the most part. You know, superintendent gets arrested for DUI. And you've got people showing up at the meeting or not. One of the things that is considered is what is the role of the employee? Teachers, administrators, superintendents are held to a different standard than, for example, the food service employee, because of the visibility of the position, as well as the requirements or the expectations of serving as a positive role model, because they hold positions of trust and must signify honesty or things of that nature. So you have this whole other nebulous piece that comes into the equation in relationship to public sector employees that you wouldn't necessarily have in other positions, that can also influence whether or not you're going to be proceeding with termination of an employee under even a just cause standard, because that becomes part of the analysis and certainly goes to the impact of whether or not you've got community outrage or community impact as well. So it falls in under that time frame or that criteria. In relation to the unavailability of work, obviously it goes to whether or not they've been convicted or things of that nature. Or on occasions, again, going back is they may be prohibited from returning to work by nature of conditions for establishment of bail or bond, or obviously the loss of any kind of licensing or those things. And that may or may not even require a conviction under the standards there. The other obvious difference is waiting for a conviction on some of these events can take a great deal of time. And whenever you're dealing with the criminal conviction, then you're looking at a much higher standard of proof of beyond a reasonable doubt for a criminal conviction versus a preponderance of the evidence standard in the arbitration or employment arena, which is 51% certainty versus a 95% certainty, as well as distinctions in relationship to what is acceptable evidence. You've got much higher standards whenever you're in a jury trial as far as the admission of evidence, hearsay, things of that nature, experts, than you would be facing in any kind of an arbitration case, where you're generally, arbitrators are very liberal on what they will allow to be introduced, and they always tell you, well, I'll take it under advisement, or take ways out in order to allow the evidence to come in and make a determination as part of their whole mixing of the soup as to whether or not it's going to be considered as part of your overall case in the scheme of things. Certainly, if we're talking about somebody who is engaging in the scenario of the dressing in drag or doing part of a show, I recognize to a large extent you do have community standards that may nationwide vary significantly between what is considered appropriate and inappropriate behavior, even in relationship to the same kind of conduct. In one part of the country, you've got like that would be no big deal, and another part of the country it might be very offensive. It just, you're going to have to deal with a community standard as well. And obviously the concern is not letting, you know, the veto power of a minority dictate all decisions either, particularly in the public sector, where you do have potentially constitutional implications with regard to what has happened outside of the workplace.
Okay, Karen?
Okay. I won't go over all of the points that Steve and Martha have covered because those are all excellent points. And I guess what I would offer as some consideration, and the question puts, I think highlights the dilemma that unions have with regard to the balance between the rights of the accused employee versus the co-workers who may feel uncomfortable, fearful, etc. Because you do have a duality of interest there that you are representing. What I might focus on or suggest be focused on, if this is a moral issue, so-called, versus a legal issue, is the fact that the concept of discipline is correction. It's corrective action, and has the employee considered, and the employee being the person who has perpetrated the conduct, have they considered changing their behavior or rehabilitating? Because that is the underpinning of corrective discipline, is rehabilitation and second chances. And coworkers need to understand that there may come a time where they find their conduct under the scrutiny of the microscope or the spotlight. And oftentimes the path of asking forgiveness and pledging rehabilitation can sway a case from disaster to success. And so that might be a focus as well. And that is something that then could satisfy many people. It can satisfy the accused because they keep their employment. It satisfies potentially the co-workers, the customers, the public, etc., because they feel that some action has come from their outrage or their complaints, etc.
All right, let's go. Next, excuse me, next slide. Please, Leah. Karen, why don't you pick up on this, and then we'll go to Martha.
On the unsuitability, the catch-all rule.
Yeah, and the ever popular conduct unbecoming a police officer, conduct unbecoming a public employee. So we're on page 8. So.
Right. Well, as I said at the outset of this session, I think if we are talking about unsuitability, at least from my perspective, the employer's case has some difficulties because unsuitability, then you're in trouble in terms of, can you demonstrate actual harm? Because actual harm is much more persuasive to an arbitrator than saying, well, we don't think the employee should be here anymore because of X, whatever the X conduct is. It makes people feel uncomfortable, or it has engendered 4 or 5 letters of protest. So So you've got that difficulty of when is the outcry, when does it rise to the level of unsuitability? And what is unsuitability? As you pointed out a few minutes ago, what might be unsuitable in the state of Michigan might be perfectly acceptable in the state of California. So it's a very difficult proof situation from, I think, the employer's particular perspective. And again, I get back to the concept that discipline is intended to be corrective. And the employee are typically, depending on what's involved, with that corrective action, it is the concept of rehabilitation and second chances. So I guess that is my perspective on it.
All right, thank you, Martha.
I want to touch a little bit on what Karen was just saying with regard to discipline is supposed to be corrective action. When I'm advising clients about, going through what is the potential continuum of disciplinary action that can be taken in a particular circumstance, one of the essential elements that I always look at or consider or walk through with the client is, and I call these the A's, is does the employee accept responsibility? If they come in and they say, yes, I have done so. And secondly, if they apologize, I am responsible, I am sorry, I did this, and they are willing, or there is an ability to atone for that kind of conduct. Those are factors that I always consider as it relates to whether or not the employee should be, whether the discipline should be moderated based upon their acceptance of responsibility and admissions along the way. If an employee comes in, they're belligerent, they're untruthful, things of that nature, then, at the beginning of any investigatory meeting, I say, I expect you to be honest. I expect you to be forthright in this meeting. And if I find out that you've been untruthful, obviously, that becomes part of one of the concerns I consider as in relationship to what the disciplinary action is appropriate. So that is an essential element of whether or not you can even make a corrective action, and it's going to be that will be the end of it. It brings closure. The employee has remediated. Juxtapose against all of that at any time is obviously the nature and the severity of the offense, whether it's been a repetitive thing or just an isolated event. Obviously, if it is something that has been ongoing, repetitive nature, such as an embezzlement where you have money being taken over a long period of time from, other sources of income or from a family member or those kind of things, obviously, all of that, if it is something of an ongoing nature, you would put that into the soup as well and make a determination as to what is appropriate conduct to take, even if it is off-duty misconduct. So these are factors that are to be considered when you're doing your analysis and making a determination of whether there's just cause or whatever the standard is that you're using for your termination procedures.
Right. Let me touch briefly on two of the bullet points from an arbitrator's perspective. In terms of criminal consequences, the nature of the crime and what the employee is doing at work. If it is a crime of honesty and some type of embezzlement or theft, and it's a cashier who's handling cash or somehow has access to money, that would be far more significant than a person working a doing manual work in the field. If it's a crime of violence and we're dealing with a cable TV installer who's going into a house, or an inspector, a water meter reader, they don't usually go into houses anymore, but or someone that is around children, firefighters, paramedics that are around vulnerable people alone in their house. That's a stronger argument to an arbitrator than just some crime that is doesn't have honesty involved or violence involved. With respect to rehabilitation, so a person is arrested and charged for drunk driving or some kind of substance abuse. So if they get a decent criminal defense lawyer, the first thing the defense lawyer will do is tell them to find God and get in a rehab program. So by the time it gets to arbitration, does the arbitrator consider the post-termination, post-discipline rehabilitation issues? There's a split on that. So rarely does a contract speak to that. Some arbitrators will view that as just cause analysis. Some arbitrators say, no, I got to take it for the facts at the time. Let's move on to page 9. Karen, why don't you talk about the 7 tests? You've talked a little bit about this, but go ahead.
Yeah. I think this is really, in any case, in any disciplinary case, this is the starting point. And regardless of whether you are the employer or the labor organization representing the employee, you should sit down with your client and go through this test. And if you're representing the employer, as Martha pointed out, you might want to sit down with them before they take the discipline rather than afterwards when you're preparing the case, if you have that luxury. But this is your roadmap, and it is a very, very helpful roadmap and persuasive to arbitrators, even if they don't equally weight each one of the factors. All right, just classically here, was the employee on notice or was there forewarning that they would get in trouble if they engaged in this conduct? That is something that is basically, were they on notice? But applying that in the context of off-duty misconduct from a union standpoint is extremely helpful, because many contracts will have some work rules, they will have discipline or code of conduct, etc. But it's clear from the contract that they're applying to the workplace, that they're not off duty and encroach in a person's private life. Is the rule reasonable? Well, it might be reasonable, like once again, if you're in the workplace, but is it reasonable to apply this standard to someone who is in the privacy of their own home or in their own car or simply off the clock, if you will? Did the employer investigate before the discipline? And this is somewhat tough if there are criminal charges that are simply pending. Does the employer wait for those charges to resolve in some way? Does it do an independent investigation? Martha touched on that a few minutes ago about different standards, etc. But you can't just let somebody else do your investigation for you. You do have to take steps to look. Is the investigation fair? Is it thorough? Is there proof of guilt? Well, is the employer considering disciplining somebody because they have been accused or because they are actually guilty? If it's the former, well, I think we all might agree that that is not appropriate. Have they taken steps to actually do their own investigation and they've come up with their own evidence of guilt of the conduct? And what is guilt? Is guilt the conduct that the employee engaged in or is alleged to have engaged in? Or is it the public's reaction or the customer's reaction to that accusation. That's pretty key. And that can turn a case pretty quickly. Has there been even-handed enforcement and consistency, assuming you've had other situations where this type of conduct has occurred off duty? Has it been treated in the same way? And again, you have to make that distinction between the person is not engaged in meaningful duties on the clock for the employer when this conduct took place. And is the penalty reasonable? Look at the severity of the misconduct versus the severity of the discipline. And here again, I beat this drum about the fact that discipline should be corrective in nature. It should be progressive in nature. Has there been that opportunity, that second chance for the employee to correct and acknowledge what is expected of him or her? So I would not neglect starting off with these factors, or saying, or at least not ignoring them because you think, well, this just deals with on-duty misconduct. It doesn't. It applies beautifully on steroids to the situation of off-duty misconduct.
Martha?
Yeah, couple things is with regard to the notice of and forewarning of rules or the reasonableness of the rules. I don't want anybody to think that you have to have 35 pages of rules before you can start disciplining employees, because it would be so expansive that you would never be able to operate if you just kept on issuing rules. There's a basic common sense expectation that people are going to act like reasonable adults too. So you don't need to articulate each and every item with great details as to what could give rise to discipline. I'm always concerned when we say things, proof of guilt. When I see the word guilt, to me, it always refers to a criminal kind of standard as opposed to proof of responsibility or culpability of concerns. So I prefer that kind of terminology as opposed to guilt. The even-handedness of enforcement, that doesn't mean that you can't have variations of what discipline is appropriate involving a particular employee or an employee group. For example, when I'm dealing with somebody who has 25 years of outstanding employment history, and it would otherwise be a dischargeable offense, even if it's off duty, I always put, and the district or the employer determines that it's not going to discharge the employee, but use some discipline less than discharge. I always include in the memorandum of why we are varying from what would be otherwise a dischargeable offense, and actually include in the memorandum your discipline was mitigated by virtue of your extraordinary employment history, the fact that you've never been subject to discipline before, the fact that you have additional contributions that you've made, whatever it is, I put that as an outline why you are not terminating the employee based upon what the misconduct is. So that in the future, if you have somebody else who engages in the same conduct, who's only been there for 5 years, and has already had several other disciplinary actions, that they can't say, well, look at what you did with that employee, you need to treat me in the same manner. So I always try to identify why you are taking a lesser discipline than you might otherwise consider based upon their background and other information. So that goes back to the paragraph G, which is the reasonableness of the discipline imposed. That if you can outline or articulate why you are making that distinction, you're going to be better off in the long run rather than just leaving it out there as something that later on, 2 years from now, 3 years from now, or whatever it is, that you can say, yeah, but the employee was treated differently because of X, Y, and Z. Well, you've just lost your credibility. And in addition to that, with the turnover of staffing, you may not have the institutional knowledge or archivist who can say, that's why we treated the other employee differently. So I always include that kind of information within the disciplinary memorandum so that 5 years from now, when it comes back forward, that you'll have, that's why the difference was made, so that you're not being tied in with something that had happened years ago.
Right. With an arbitrator's perspective, I think almost all arbitrators, if a person was found criminal, in a criminal case found guilty, an arbitrator almost has to take that as those facts are established. If the person is found not guilty, some arbitrators then say, well, then he or she didn't do it. I think that's incorrect because of the difference of burden of proof that Karen and Martha talked about at the beginning of the session. With respect to the factors A and B, where this will come up a lot in the future is when someone goes on a rant off duty on social media. We're going to get to that in a minute. But to what extent the employer has a policy, a reasonable policy that's understandable about social media. There are ones written by lawyers that only the Supreme Court could figure out, maybe. And there are others that are written in layman's terms that are very understandable. And that is something well worth management and unions time sitting down and trying to hash out. Let's go to the next page. I want to spend some time on social media. So let's, we've talked about a lot of this. Karen and Martha, just maybe pick out one bullet point, just touch on it quickly because we kind of covered this page pretty well.
Were you going to go first, Karen? Oh, go ahead, Martha. I was just trying to pick out one bullet point.
Okay.
If you're ready.
With regard to, I think we've kind of touched on most of these.
Yeah.
Okay. Karen, unless you have something you're burning to say, let's move on to the next. We kind of covered this one. All right. Now, here we start getting into really tricky stuff. What I'd like Martha talk about the second bullet point in particular, and then anything else, and then you've touched upon contract language, but talk about the constitutional issues, and then we'll have Karen weigh in.
The constitutional issues obviously is a whole different arena and would apply primarily in the effect of for public sector employers. And in the basic of the constitutional implications are obviously the First Amendment rights of freedom of speech. And how far does that go? The basic premise, by virtue of a whole series of Supreme Court decisions, is in relationship to whether it is a matter of public concerns, the broader public concerns, or is it simply an individual's personal interest that's at issue in relationship to what they're saying outside of their employment. So for example, if you have an employee who is going, and I'll go ahead and on Facebook and saying the school district or my employer did the following to me, I've been demoted, I've been fired because of whatever it might be, or I'm being, treated in such a manner, my pay was reduced, whatever it might be. If it's personal to them as an individual, then it is not going to be protected under the First Amendment freedom of speech. However, if it is my employer is making reductions in staffing that as a police or firefighter is potentially putting our own interest and our own safety at risk because of cutbacks in our ranks, then that has broader public implications, and accordingly, they are going to be subject to protections under the First Amendment freedom of speech, depending upon how far they go into that context. And obviously, the social media becomes so much a part of all of this these days.
Karen?
Okay. Just a couple of points to add, because I think Martha really covered it beautifully in her comments. You know, I tell people, you know, nothing's really private anymore. I mean, if you post something, it's going to get back to someone. I mean, even if you're posting it on Facebook to your personal friends, etc., you have to take ownership that you may be responsible for someone to finding out. And then the question will become, is it viewed in a negative light? Is it protected for some reason? Maybe because you're trying to have a call to arms of coworkers with regard to a working condition issue, etc. You can cover yourself with the umbrella of protection of the National Labor Relations Act or the Public Employment Relations Act. But you do have to start with the premise that what you say in social media is going to be discovered. And you've got to be careful. I mean, that's essentially what we tell our members, is that you need to be careful in your speech. Because yes, you may be able to claim, well, this is free speech, this is some violation of Michigan's Internet Privacy Protection Act or the National Labor Relations Act, etc. But you can't guarantee that that is going to protect you.
So under the same rule that nothing good happens after midnight, nothing good happens when an employee, after drinking or being extremely angry, goes to their keyboard and does a post. Let's go to the next page, please. So we've covered the last 3 bullet points. The first bullet point, Karen and Martha, I want to get to the next couple of slides, but just talk very briefly about how you approach if the employee has been allowed to work after some period of time after the employer learns about the off-duty misconduct. Martha, why don't you go ahead?
With regard to being allowed to work sometime after the misconduct has been discovered, maybe there's a reason for it. Maybe you didn't have all of the facts, or maybe it didn't get to the right level of authority. That can obviously, if the upper management didn't know about it, sometimes the supervisors have different standards than what the HR office would be. I would investigate fully as to why it didn't get moved forward. And obviously the amount of time and the nature of the conduct and the notoriety within the community can be determinative of that as well. If it's out there on the front page of the newspaper and it takes 4 months for the employer to start doing something about it, I would, really question what happened here and why the breakdown. So you better have a good explanation for a significant delay. And, if it's because you've been conducting your investigation, particularly, based on a Title IX or a Title VII for harassment or discrimination by an employee against another employee or whatever it might be, then, if you've been investigating it all along, then that's a sufficient explanation. Or if additional evidence comes out that it was what you thought was this event, and now you're getting more information showing that it's significantly more impactful than what you originally anticipate, can also be relevant as to
Karen?
why.
Yeah, I would just emphasize from the labor standpoint that if the employee has been permitted to continue working for a substantial period of time and has done so relatively satisfactorily, I think that's very persuasive evidence to an arbitrator and undercuts the employer's other arguments, other potential arguments that their business has been harmed, that they've lost their reputation, or it's been damaged severely, that the employee is unsuitable because it belies those factors. At least that's what I would argue. And Martha's correct, from an employer standpoint, you would have to say, well, here is why. But even the why may not be sufficient from the employer's standpoint.
Yeah.
If in fact the end result is that the employee
Yeah.
has successfully continued working.
I would say as an arbitrator, it better be a good why. It's not absolutely no, but it better be a good why. Let's go to the next page. This applies to most arbitration cases, but comes up. So with hearsay, arbitration, grievance arbitration is different than courtroom evidence, because most arbitrators will generally take some hearsay. Advocates should remember that there's only one person in the room who knows nothing about the subject of the contract during the hearing, and that's the arbitrator. And I would say, and so the arbitrator is trying to synthesize the case question by question while also anticipating an objection and trying to put it together while trying not to get an opinion or conclusion formed in their head during the course of a hearing. So it frequently makes more sense to allow the hearsay in and then decide later whether it is reliable or not. So arbitrators, and I'm guilty of this, will say, I'll let it in, I'll give it the weight it deserves, and everybody sits there going, what the hell's that mean? You almost never, however, see an opinion that a key factor relies on hearsay evidence, but it may have helped sway the arbitrator when they're sitting at their desk later putting it together. With social media and emails, anyone can do a post and sign it Reg Grange at Illinois 1928. Now, did Reg Grange write that email, or did someone else write it and create an email address calling themselves Reg Grange? And if you don't know who Reg Grange is, you're not, you have to pay homage to our host, the University of Illinois, and look him up afterwards. So the employer has to establish, if the employee denies it was them, that it was that was the true author. Now, if there's a photograph of the person on their Facebook that they're actually playing hooky and having fun when they call in sick, then that's pretty compelling evidence. When you have non-employee witnesses, does your state allow the arbitrator or to subpoena witnesses? Michigan changed that maybe 10 years ago, gave subpoena power. Other states may not have that. So are you going to be able to get the non-employee person to come in and testify 8 months after the event? Police records are very tricky. I remember when I had brown hair as an advocate, and I introduced the police record, and Richard Mittenthal, who is considered the dean of arbitrators, took it over the objection of the union advocate and said, well, police records are highly reliable. And I thought, well, okay, I'll take it. I'm not sure I agree with that, but you know, it would be better to hear from the police officer testify live. Can't always do that, but probably they're going to be admitted. I'm going to move on because the next slide's very important. Remote work. So, you know, it clearly has gotten into a gray area of what is on duty and off duty. There's clearly differences in generations of, is work 8 to 5, 9 to 5, or is it 8:30 p.m. at night when people are sitting at home looking at their smartphone? And that can be an issue. Martha and Karen, just do a short summary on this.
Well, with regard to remote work and things of that nature, and whether it's off duty or not, anything that goes through the employer's server, I consider to be within the school district or the employer's jurisdiction. So if it's going through their server, they can usually access it if they're so inclined. And again, in the public sector, you have the Freedom of Information Act, which obviously if people ask for anything under the Freedom of Information Act and it is subject to disclosure under those provisions, then it's, even if it occurred off duty, then I kind of consider it within the employer's jurisdiction to address the behavior, particularly if it involves threats. And we've had lots of, in the recent past, we've dealt with a lot of political things that were posted that were inappropriate and of questionable nature, just because of the polarization of politics these days. And we've certainly addressed employees in relationship to what they have posted of a political nature when they have used the school district or the employer's email address, or it went through our server somehow.
Okay, Karen?
Okay. Well, again, from the labor perspective and defenses and arguments to be made, you start with the general proposition of, was it working time or not? And if you are working remotely, how has regular working hours, how have they been defined? Have they been defined? What is the expectation of when you are supposed to be on the clock, if you will? I mean, typically, if you were working an 8-hour job in an office, those 8 hours have to be put in at some point in the remote location. Have the parties come to a conclusion as to when those hours should be put in? That's the first issue, I guess I would ask.
Yeah.
And if it's very fluid, then anything could become off duty. I might have just been in a remote meeting for 2 hours and then say, well, I was taking my lunch break now, or my coffee break, or whatever. And so I was technically not working at that particular.
Right. So as an arbitrator, I would look at, does the contract say what the workday is? What's the practice? Does the employee get paid normally during that time? Is a practice of that? How's the employer done? Let's go to the next slide. We're going to wrap up real quickly because I'm getting the eye. So we've talked about a lot of this, but there are unique issues mostly in the public sector with teachers, police officers, firefighters, postal workers. So an arbitrator will look at, do they have constitutional rights if the arbitrator has jurisdiction to do that? And can the employer somehow say that violates the public trust? Does that impact their ability to provide services, get millages passed and so forth? Go to the next slide. So we've talked about this, but again, in determining whether there's just cause, look at, is there a rule or policy, or is it so clear we don't need a rule against murder? But other things, is there something warning the employer, guiding the employee what they can and can't do from the management's perspective? The second factor, can the employer establish, or can the union undercut, to what extent this rule or policy affects the employer's operation? A lot of these cases, the future will be social media posts, and so that policy, if there is one, will come greatly into effect. Last slide. So thank you for your time. We have our contact information in our bios if you have questions. A lot of this comes down to case by case, but the criteria we covered in the last area are guides for arbitrators should be guidelines for management to follow. There should be guidelines for unions to say, is it appropriate what management did, or should we try and reverse this? So with that, I thank you for time. I thank the University of Illinois and Lyra, and have a good day. Take care.
Thank you very much.
Thank you. And we can stop recording, Leah. Thank you.